welcome to Crime in Court. My name is Heather, and this is an update in the Delphi case. We're going to be talking about or reading through, rather, the court documents that recently dropped this past week. I've done several videos that I'm dropping, day by day here to catch us up on all the different filings. Today, we're going to go through the defense's filing to disqualify Judge Gull. And we're going to do this in two parts because it is a 40-page document. So I'm just letting you know ahead of time that this is going to be a two-parter. All right, so first off, I do want to start us off with the Richard Allen's affidavit in support of this motion. So like clockwork, here comes Hazel. She needs her blanket. She's going to want to get cozy. All right, sorry. And of course, she's messing with the equipment here. All right, so Richard Allen's affidavit. Oh, let me shrink myself first. My screen keeps flickering and it is so irritating. All right, sorry. So Richard Allen's affidavit in support of his second verified motion to disqualify Judge Gull and request for findings of fact and conclusions of law upon denial of this request if the court denies this request. So comes now affiant Richard Allen by and through counsel and swears and affirms the following are true. Number one, my attorneys have reviewed with me all the facts contained in the defense second verified motion to disqualify Judge Gull and request for findings of fact and conclusions of law upon denial of this request if this court denies this request. So basically what I just read. All right, number two. I agree with the facts contained in the motion and ask that the contents in that motion be incorporated into this affidavit. So he agrees that whatever's in that motion, he is affirming to. All right, so while I would like to believe that Judge Gull can be fair and impartial, I believe that a rational inference of bias exists against me, and more so against my chosen attorneys, and I fear that I will not be able to receive a fair trial based upon the facts contained in the first motion for Judge Gull to recuse herself, as well as the new motion for Judge Gull to recuse herself. I believe we went through um, the first motion to recuse Judge Gull. I'll have to look uh, through my videos and see if I've done that one. If not, I'll have to do it. I believe we've done it. And if we have, I will put it in the description. If I haven't done it, I'll make a new video. All right, so moving on. Where were we? Okay, to recuse herself. Number four, I would ask Judge Gull to please step aside and let a new judge take over the case that will not show bias against my attorneys or at least the appearance of bias. I swear and affirm that the statements I made herein are true and accurate to the best of my knowledge. He signed it. And here we have a little bit of fact. All right, so facts establishing the timeliness of Richard Allen's request for change of judge pursuant to RCP 2.4C2. And we'll read all about that in a little bit because that's going to be in the motion. All right, so since the last motion for disqualification was filed, Judge Gull has continued to show unfair treatment to the defense as laid out in the motion that we're about to read. So this includes the most recent event of sending a Sunday morning email informing the defense that she was significantly cutting their time to present their case at trial, and also telegraphing to the prosecutor legal strategy. Wait, what? She's giving the prosecutor legal strategy? Or allowing them to see their legal strategy? Is that because of maybe because of the filings that were ex parte that were supposed to be sealed off from Nick McClelland, but he had access to it and read it and quoted from it in another filing that was pretty dumb. on his part. All right, so I think that's what they might be referring to potentially. I don't know. The Sunday morning email informing the defense, and then telegraphing to the prosecutor legal strategy. That could be it. I'm not exactly sure. The cumulative effect of all the examples of bias spread over the two motions took place well beyond the time frame originally required under rule. And it is signed Brad and Andrew for the defendant. So now we're going to get into, excuse me, the actual motion. And this is going to give us a little bit of background with the rule, the Indiana Rules of Criminal Procedure, and then it's gonna get good. Just you wait. All right, so the defense's second verified motion to disqualify judge and request for findings of fact and conclusion of law upon denial. So again, remember they asked for conclusion of law. You need to give us your findings of fact and conclusion of law, which is your job as a judge. You're supposed to go back into your little chambers and look back at other case law and then cite it and use that as to why you made your judgment. It's supposed to make sense and it's supposed to be verified and backed up by law. Find fact and findings of fact and conclusions of law. So that's what they're asking for as a reminder. All right, so comes now the accused, because the reason they're asking for that is because if you're not aware, she keeps denying everything, all of their motions without hearing. She'll just put out a very general, denied without hearing kind of language, and there's really no more information about that. So they want the findings of fact and law. All right, so comes now the accused, Richard M. Allen, by attorneys Rosie and Baldwin, and pursuant to Rule 2.4 of the Indiana Rules of Criminal Procedure and the Indiana Code of Judicial Conduct. I struggle with that word. Move for a change of judge from Judge Frances C. Gull or her recusal from the cause. In support of said motion, Richard M. Allen swears and affirms as follows. Legal standard. Number 1, the filing of a motion for disqualification and or request for recusal strips the court of jurisdiction to decide on any matters unless a ruling on the disqualification motion occurs. So any other matters in this case need to go to a screeching halt. So that hearing that they're supposed to have, that's got to get canceled because they're supposed to have a hearing this week, May 21st through the 23rd, I think. And that's to rule on certain motions that are still outstanding. Well, she's right now, because of this motion to disqualify, she has no jurisdiction whatsoever to rule so far on any other outstanding things going on in the case. There's several motions still outstanding. All right, so number 2, pursuant to Indiana Criminal Rule of Procedure 2.4b, the state or defendant may request a change of venue from the judge only for bias or prejudice. The motion must be accompanied by an affidavit signed by the defendant or the prosecuting attorney. So that's already covered. They've got it. The Richard Allen's affidavit we just read. The affidavit must set forth facts and reasons for the belief that bias or prejudice exists. If the defendant signs the affidavit, the defendant's attorney must file a certification that the attorney believes in good faith the facts recited in the affidavit are true. The court must grant the request if the facts recited in the affidavit support a rational inference of bias or prejudice. Not they must. The court must grant the request. Put another way, the facts contained in the affidavit must show there is a reasonable basis to question the judge's impartiality toward Richard Allen and his defense team. And it's going to be hard to convince someone that there is a reasonable bias, um, or reasonable basis for their bias. But I mean, I think that Judge Gull has given us plenty of examples here. Number three, I looked it up. It's committant, concomitant, which just means like in accordance to or associated with. So, associated with Indiana Crim Rule 2.4b is Rule 2.11 of the Indiana Code of Judicial Conduct, which requires a judge to disqualify himself or herself when the judge's impartiality might reasonably be questioned. And I think the whole world is now questioning Judge Gull's bias, or at least appearance of impartiality. Such is the case in this cause of action. The rule on disqualification and the canon on recusal both adopt a threshold of reasonableness, i.e., would an objective person have a reasonable basis doubting the judge's impartiality? Number four, the comments to Rule 2.11 of the Indiana Code of Judicial Conduct provide additional guidance. Under this rule, a judge is disqualified whenever the judge's impartiality might reasonably be questioned, regardless of whether any of the specific provisions of paragraphs A1 through 6 apply. In many jurisdictions, the term recusal is used interchangeably with the term disqualification. That's interesting. Number two, a judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. Number five, a judge should disclose on the record information that the judge believes the parties or their lawyers might reasonably consider relevant to a possible motion for disqualification, even if the judge believes that there is no basis for disqualification. And I've said on this channel before that in Indiana, if you want to if you ask your judge to recuse themselves, you have to ask them. Like it has to go through them. And if you're biased and already, angry or want, have some kind of something, some vendetta against the defense team, and you move forward acting like you're just some impartial judge, but yet everything you do, you rule in favor of the state and you deny everything without hearing for the defense. It's just a little bit of what's been going on. It's crazy. All right, number five. The test under the canon is whether an objective person knowledgeable of all the circumstances would have a reasonable basis for doubting the judge's impartiality. The question is not whether the judge's impartiality is impaired in fact, but whether there exists a reasonable basis for questioning a judge's impartiality. And I think there has been a lot of media on this, media coverage about this case, but I don't think that they're actually covering what's really going on in the court documents, which is why you guys are here getting the news from YouTube rather than going to your local news channel or your national news channel because they're not really telling you this stuff. They were only reporting on whatever sensational part of it they choose and run with that. And oftentimes it's in favor of the state and disparaging of the defendant. So, just as a society, I think we need to do better, especially media wise. People in the media need to do better, but that's a whole nother story. All right, so moving on. The question is not whether the judge's impartiality is impaired, but in fact, whether there's a reasonable basis for it, which I think my point about so much media coverage was that I think that the attorneys Alan's attorneys could find a ton of media coverage on it if they had been covering the case properly, but they probably haven't been. But they could probably find stuff on YouTube that expresses the sentiment that Judge Gull is very biased. They could probably find comments all over the internet 'cause it's everywhere. people just really are seeing it now. So I'm sure that they could, in fact, use some social media in their favor to maybe support this. I don't know. Something to think about there. So Indiana, oh, that's from Tyson versus State, Indiana, 1993. All right. Opinion of Chief Justice Shepard recusing himself from consideration of a petition for transfer. This legal standard is not lofty. So, like, it's not a high bar that you have to meet. It's just the appearance of impartiality. It doesn't even have to exist. The accused, 6, has a federal due process right to an unbiased judge under the 5th and 14th Amendment to the U.S. Constitution. Judicial bias is one of the narrow classes of constitutional violations that implicate structural error. Cases of judicial bias involve a denial of the most fundamental constituents of due process, so fundamental that a conviction in their absence screen. Now it's not coming back. Okay, sorry. So fundamental that a conviction in their absence is indecent even if the defendant is plainly guilty. So even if if a judge were to preside over the proceedings for a defendant and the entire time they appeared very biased, even if the person was like no doubt guilty, it's still reason enough to um, cause like reversal of error and things like that because of the fact that you have a biased judge, even if they're plainly guilty. Structural errors render a criminal trial fundamentally unfair and are not subject to harmless error analysis. Number 7, the preamble to the Code of Judicial Conduct provides that judges should aspire at all times to conduct that ensures the greatest possible public confidence in their independence, impartiality, integrity, and competence. I think a lot of people would say that they don't have a lot of faith in Gull or think that she has much integrity or impartiality right now. All right, so next, Richard Allen incorporates his first verified motion to disqualify, filed January 28th, 2024, as if fully set out herein. So after the Supreme Court quickly reinstated the defense following oral arguments. So after the Supreme Court, they ruled to put to put Rosie and Baldwin back immediately on the case. Come on. The screen is being a butt. I'm getting so irritated with this thing. I don't know what's wrong with it. Technical errors, always. All right, so try to read it on here. One second. Sorry, I had a cough there for 1 minute. All right, so let's continue on. So, after the Supreme Court quickly reinstated the defense following oral arguments, on the same day, the Indiana Supreme Court did not grant Allen's request for Judge Gull to be recused based upon the limited record set out at the time by Allen's appellate counsel. I was hoping that that would help, but I don't know if it did. It's so freaking annoying. All right, sorry. Thing keeps moving. So they're saying there wasn't enough on the record for the appellate counsel really to put anything down regarding Gull's bias. how she's, um, in which way she's displayed it. There weren't enough fleshed out details about her bias. Here's number 9. On January 28th, 2024, the defense filed its motion requesting Judge Gull to be disqualified, knowing that the Indiana Supreme Court was not aware of all the reasons Allen would cite to that show a rational inference of bias. So, again, they didn't know that there were as many instances at the time when the Supreme Court made its decision. All right, so number 10, the defense cited 18 reasons for Judge Gull to recuse herself in that January 18th, 2024 motion, and she denied it. So 18, not enough? Okay, let's come up with some more then. There's plenty of reasons. So this thing is 40 pages long and there's many points. You'll see. All right, so number 11, on February 6, 2024, before finding out exactly why the Indiana Supreme Court rejected Allen's request to have her removed, Judge Gull denied the defense request for her to be removed. So she just went ahead and ruled on it without first finding some information or finding out why the Supreme Court, what the Supreme Court's opinion was. So the Indiana Supreme Court's opinion detailing the reasoning for not taking Judge Gull off the case was issued on February 8th and certified on February 15th. But she denied their request prior to that. All right, so number 12, Judge Gull. Judge Gull's one sentence denial of the defense motion to have her disqualified stated, the court, having defendant's verified motion to disqualify filed January 28th, 2024, defendant's affidavit filed January 28th, 2024, certification of Richard Allen's attorneys filed the same day under advisement, and having considered the pleadings, now denies the verified motion to disqualify without hearing, as the Indiana Supreme Court unanimously denied defendant's previous request on January 18th, 2024. Emphasis added. So her reasoning to not recuse herself from the case is because the Supreme Court didn't take her off the case, which is stupid because she could still be biased. She could still be showing an impartiality. And the Supreme Court, that's not what they were necessarily looking for. Or, they weren't, they wanted more solid fact, not, it could just be the way that she's ruling type of thing. You have to really prove bias. And it's difficult to do, especially for a judge or a prosecutor or something like that. Right, number 13, had Judge Gull waited only 2 more days before ruling on the defense motion to have her disqualified, she would have had the benefit of learning exactly why the Indiana Supreme Court did not disqualify Judge Gull. Number 14, on page 16 of its order reinstating Baldwin and Rosie, the Indiana Supreme Court stated that Allen, through his attorneys, did not identify anything she had done that demonstrates she isn't impartial. Indiana Supreme Court opinion, page 16. Number 15. At the time the Indiana Supreme Court issued its opinion, the court did not have the benefit of reviewing the 18 reasons the defense cited in its January 28th, 2024 filing, which the defense claimed supported a showing of Judge Gull's bias. So the Supreme Court did not have the first filing to disqualify Judge Gull. That was not something that they based their decision on. Therefore, it's new information that they need to evaluate, and it can't just be, oh, denied without hearing because because the Supreme Court loves me and now I can do anything I want and just deny everything without hearing for you. That's how she took it. I believe that's how she took it. Anyways, Certainly, some of those 18 reasons were included in the Indiana Supreme Court's opinion as, by themselves, not being enough to cause Judge Gull's recusal. However, many of the examples of bias identified by the defense in its January 28, 2024 motion were not cited by Allen's lawyers in their request for Judge Gull to recuse herself. Number 16, in other words, Judge Gull's use of the January 18, 2024 Supreme Court ruling as a sort of blanket immunity to support her decision to not disqualify herself was wrong, and that the Indiana Supreme Court's February 8, 2024 opinion leaving Judge Gull on the case was clearly based on a very finite set of reasons argued by Allen's appellate attorneys and not the longer list of reasons articulated by Baldwin and Rosie in their motion to have Judge Gull disqualified. Whew. Judge Gull ignored that longer list and instead erroneously used the Indiana Supreme Court's ruling as her reason to remain on the case without any legal analysis and before reading the Indiana Supreme Court opinion. Number 17. The defense is requesting that if Judge Gull does anything but recuse herself from this case, that she issue findings of fact and conclusions of law that support her decision to deny the defense motion rather than a one-sentence order summarily denying Richard Allen's request, which uh, she has been in the habit of doing lately. She's just denied all rule and procedures. She's just deny without hearing. Oh, Nick, you want something? Nick McLeland, prosecutor? Sure, I'll give that to you, but Alan's attorneys want something, I'll just make them wait or deny without a hearing. All right, 18. In addition to the reasons cited in his January 28th motion, Judge Gull has revealed a rational inference of bias towards the defense based on the following. A. Judge Gull engaged in ex parte communications with the state of Indiana. B. Judge Gull interfered with a properly subpoenaed defense witness. C. So I think somebody was subpoenaed and she told them not to come or something. I don't know. There's something about that. I hope it comes out in the it comes out later. All right. So Judge Gull interfered with a properly subpoenaed defense witness. So told someone who was subpoenaed not to show or something like that. C. Judge Gull treats the prosecution more favorably than the defense. That we can see for sure. D. Judge Gull engaged in the act of prosecuting Richard Allen by inviting the prosecutor to file pretrial motions seeking the limitation of evidence of third-party culpability and also forecasting the outcome of such a request by the state. She's like helping them in this case and telling them almost or holding their hand of what they should do. And this third party culpability, it's BS that they want to limit the defense's ability to defend their client. That is their strategy, that's their theory, that's what they believe, and they're trying to make it so that the Odinist ties and the ritualistic life, ending of life type of thing, um, that would all be banned from the trial if Nick McLeland gets his way. And we know how Judge Gull rules, especially when it comes to the defense, and it's not going to help the defense, so she's going to probably approve or grant their stupid um, motion if she doesn't recuse herself first. She needs to do that first. All right, so G, Judge Gull placed blame on defense counsel and its staff for administrative failures in maintaining confidentiality of ex parte defense filings, whereas evidence revealed that failures were on the court side of the filings. So they must have investigated this because so there were some ex parte communications that I was referring to that Nick McClelland got his eyes on. He's not supposed to look at them. They filed it appropriately. The defense did. Filed it under the ex parte category, whatever you want to call it, and that means that only the judge and the party that's filing it is able to see it. However, it was all available for the prosecution to see, and not only did they look at it, they cited it in their documents as to whatever they were like trying to support. But whatever that motion was where they actually cited it, they cited it like deep within the document too. So it wasn't like they just skimmed the first couple pages. But that motion that Nick McLeland wrote that cited this ex parte communication that he should have never seen or had any kind of way of getting a hold of it, he had it for some reason, and that's concerning. So yeah, the ex parte uh, filings. H. Judge Gull failed to conduct her own internal investigation into allegations of leaks coming from her own staff while facilitating contempt proceedings against Richard Allen's chosen attorneys for leaking confidential information related to this case. Okay, so Judge Gull just immediately put the blame on Richard Allen's attorneys for leaking this confidential information. She failed to look into the leaks. She failed to actually like do any kind of internal investigation is what they're saying. So she basically is taking Nick McClelland's word against the other for no reason. I, Judge Gull, effectively denied Richard Allen his right to a speedy trial by not requiring the prosecution to follow the same time restrictions at trial as she was forcing the defense to follow, which forced the defense to seek a continuance of the May 13th, 2024 speedy trial date, which it's now set for October 14th, I think. Um, yeah, so I've said in another stream, I think it was a different stream, that Judge Gull really forced the defense to have to continue because of the fact that she was limiting their time of the trial to like 3 weeks or something. Like it was ridiculously short. And told them, there's under no circumstances is it going longer than this. And she made some kind of comments about not letting in third party culpability because she knows exactly what that is, like almost like in a threatening way, like you defense attorneys don't understand what the third party culpability rules are, and I do, type of like admonishment, even though they didn't do anything wrong. So it was in an email. So she just is incredibly rude to them. When she came out with her findings for the contemptuous conduct hearing, she basically disparaged them and their reputation, but found them in not having been in contempt. But she had to make sure that everybody knew that she really had a distaste for them. So, anyways, Judge Gull. Ex parte communications and interfering with defense witnesses. Number 19. Judge Gull participated in ex parte communications with the state of Indiana through its witnesses to the detriment of the defense. So Judge Gull was talking to witnesses with the state of Indiana, or talking, yeah, through its witnesses. Wow, unbelievable. Number 20. On April 5th, 2023, Richard Allen, by counsel, filed his emergency motion to modify safekeeping order based on the conditions of his confinement at Westville Correctional Unit. Number 21. On April 14th, 2023, Judge Gull entered an order stating the Indiana Department of Corrections was authorized to move the defendant within the Department of Corrections to accommodate his medical and physical needs pursuant to medical directives by DOC, Department of Corrections, physicians, psychiatrists, psychologists. Number 22, on May 4th, 2023, Mr. Allen, by counsel, filed his motion to reconsider and request for due process hearing, which the court set for hearing on June 15th, 2023. In preparation for the hearing, the defense served a valid subpoena on witness and Westville inmate Robert Baston to appear for the June 15th, 2023 hearing. I think he had things to say about the fact that Richard Allen was being mistreated in the Westville Correctional Facility by Odinist guards. Number 24, when a deputy from the Carroll County Sheriff's Department went to the Westville Correctional Unit on June 14th to transport the inmate to the hearing, the inmate became uncooperative. So this inmate, Robert Baston, who was supposed to speak about how Richard Allen's treatment in prison was, he was a fellow inmate, and he would not cooperate with the people trying to transport him to the court. Carroll County Chief Deputy Tobe Lesenby contacted Judge Gull about the situation, and Judge Gull told Deputy Lesenby to leave the inmate there if he didn't want to come to the hearing, I think is what they're supposed to say. So, yes, he has a subpoena. This guy is, so that is what that line meant. He has a valid subpoena that needed to be served on Robert Baston, who I believe was threatened to not um, testify. Threatened by Odinist guards, maybe? I don't know. But, anyways, so Robert Baston was uncooperative and did not go to that hearing or that whatever date that was. My little light covers moving around. All right. So she says, leave the inmate there if he didn't want to come to the hearing. Well, no, lady, he has a subpoena, so the guards need to drag him and take him to court, whether he wants to go or not. He's got a subpoena, but not in Judge Gull's court. She doesn't mind if people with subpoenas don't come. She says, just leave them there if they don't want to come to the hearing. Yeah. So if you get a subpoena by Judge Gull, just don't go. Don't take that advice seriously. That's bad advice. But apparently, it works for inmates. Number 25, Tobe Lesenby was the first witness called by the prosecution at the June 15th, 2023 hearing and certainly will be called as a witness at trial. Yet Judge Gull and or her staff communicated with this prosecution witness the day before his testimony without the full disclosure of said communications to the defense. Yikes. So a little talkie-talkie communication going on. Additionally, Tony Liggett, who was a witness at the June 15th, 2023, and will be a witness when this matter goes to trial, issued a report in which he stated, my screen just went out again. All right, stated on the 14th day of June 20, excuse me, on the 14th day of June 2023, communication with the court was established by Sheriff Major Chief Deputy Tobe Lesenby, wherein Major Lesenby was advised by the court to disregard any further efforts to retrieve inmate Baston from the Westville facility. Emphasis added. He was advised by the court. So Judge Gull said, you can disregard any future subpoenas on that guy. What? What judge ever does that? There's something fishy here, guys. If a judge says, just let that guy go. He doesn't need to come and testify in the court, even though he has a subpoena. and we know exactly where he is. We can bring him in. We've got transport waiting for him. This just gets more and more ridiculous. All right, number 27. On June 14th, 2023, Judge Gull sent an email to the party stating, FYI, the Carroll County Sheriff's transport officer went to Westville to pick up the inmate requested by the defense team per subpoena. The inmate refused to come out of his cell and demonstrated an ability to fight if forced. The transport officer stood down and has left the facility to return to Carroll County without said inmate. I have asked for a formal written report on these activities, which will provide you all, which I will provide you all upon receipt. Interesting that she just lets him get out of coming to court to testify. Number 28. What Judge Gull failed to tell the defense in that email is that she was the person who used her authority as judge to direct the Carroll County Sheriff's Department to ignore a valid subpoena of a defense witness scheduled to testify at an important hearing on behalf of the defense. Yikes. All right, so it is not unusual. Did I miss? Oh no, I didn't miss a footnote. Okay, good. Number 29. It is not unusual for those incarcerated to not cooperate when being transferred from one facility to another when presented with a subpoena. Judge Gull has detailed on more than one occasion her vast experience on the bench. It would be surprising if this situation has not occurred in her tenure on the bench. I'm sure there's a lot of people that don't want to testify, especially if they've got like deals and whatnots and they're like, I don't want to go. Or they're afraid for some reason. I'm sure there are tons of inmates that refuse or at least try to refuse transport. All right. However, the lack of cooperation of an inmate is not a legal justification for a judge to direct the Indiana Department of Corrections or a county sheriff transport officer to simply ignore a valid subpoena. Number 30. Proper method for a judge facing that situation would be to not communicate in an ex parte fashion with witnesses who are involved in the case. Rather, it would be to contact the attorneys for both parties, prosecution and defense, explaining that the court has been informed that there is a potential problem with the transportation of a witness from the IDOC and that the court will not talk to the state of Indiana without talking to both sides. Sorry. Then, after both sides are engaged, to work on a solution. If the defense still wanted the witness to attend the hearing, then law enforcement would still be required to use whatever means necessary to transport the inmate, unless the state of Indiana filed a motion to quash the subpoena, which was granted by the court. So either the state of Indiana filed a subpoena to quash the whatchamacallit, or they filed a motion to quash the subpoena, is what I'm trying to say. So either they did that or the judge just blatantly, flat out of nowhere on her own said, just ignore this court order, no worries. Number 31. After the June 15th hearing, Judge Gull denied Mr. Allen's motion to reconsider, stating the evidence presented demonstrated at the hearing on defendant's motion to reconsider did not support many of the allegations advanced by defendant counsel. In fact, the evidence presented demonstrated that the defendant is treated more favorably than other inmates housed at the Westville Correctional Facility, and I'm only smiling because I know that's a bunch of BS. This is disingenuous given that Judge Gull prevented the defense from presenting the very evidence that she said was lacking. Number 32. Any perception of Judge Gull's bias was supplanted with proof of actual bias when Judge Gull denied Mr. Allen's motion to reconsider, claiming a lack of evidence when she prevented Mr. Allen from presenting the testimony of Mr. Baston. So she basically violated. She just continues to violate Richard Allen's rights, and in here she's violating just by staying on the case with any kind of perception of bias. She is violating the rules of conduct, I guess. Whatever statute we cited before. All right, it's number 33. Communicating with state's witnesses is in an ex parte fashion provides a rational inference of bias. So she was communicating with the state's witnesses directly. That's not good. Number 34, issuing a directive for a state's witness or Carroll County Sheriff, to be more precise, to ignore a valid subpoena to the detriment of the defense provides a rational inference of bias, I would say. So, number 35, we're way past the 18 from their original points. Number 35, Judge Gull's failure to fully inform the defense of her involvement in directing law enforcement to ignore a properly issued defense subpoena demonstrates deception. Such deception to the defense provides a rational inference of bias against the defense. So she didn't tell the defense after she did what she did. She's awesome. Right. Recent ex parte communication and additional evidence of Judge Gull's favorable treatment to the state of Indiana as opposed to her treatment of Richard Allen and his defense team. I'm sure there's lots of these. On May 3rd, 2024, the defense deposed Sheriff Tony Liggett. During this deposition, it was learned that the court has engaged in activities with law enforcement. What? The court has engaged in activities with law enforcement and prison representatives regarding Richard Allen's housing, both during scheduled jury selection in Fort Wayne and during the scheduled jury trial in Carroll County, Indiana. Okay. So it's not as like she's in cahoots. That's what I thought they were trying to say. But she's engaged in activities with law enforcement and prison representatives regarding housing. Okay. So not as devious as I thought it originally sounded, which is good to know. She's not as evil as I thought. Right, the court failed to communicate any of these plans to the defense in advance of the court's actions. Again, the court appears to have engaged in ex parte communications with the state of Indiana. Number 37. I mean, that's just so wrong on so many levels. The court engaging in communication with witnesses in the state of Indiana, meaning Nick McLeland and the prosecutor's office. She's engaging in conversations one on one with them that the defense is not privy to. I don't like it, and that shows tons of bias right there. All right, so moving on, number 37. At the June 15th hearing concerning the pretrial housing of Richard Allen, Sheriff Liggett claimed that the only reason he objected moving Richard Allen to the Cass County Jail, approximately 25 minutes from Delphi, was due to the lack of manpower to transport Richard Allen to and from jail. 38. During his May 3rd deposition, Sheriff Liggett acknowledged that Richard Allen was set to be housed at the Tippecanoe County Jail during the scheduled jury trial and that the transportation of Richard Allen to and from the courthouse was arranged. Therefore, there is no need to continue to house Richard Allen at a prison some 2.5 hours from Carroll County during the pendency of this case. So while we're still in litigation, move my client closer to me. There's no reason for him to be so far because we've got the Tippecanoe County Jail that's willing to take him. So bring him back. 39. According to Sheriff Liggett, Judge Gull is aware of these circumstances. 40. Despite this, Judge Gull failed to communicate or even inquire with the defense about Richard Allen's housing circumstances. She didn't even ask. That means that she's part of keeping him in this isolated state. 41. It is also true that despite alternative detention options, Judge Gull has failed to intervene and protect Richard Allen, who, at this moment in time, is presumed innocent from his appalling confinement conditions by facilitating a more suitable pretrial housing arrangement for Richard Allen while he awaits trial. So get him out of solitary and bring him to like a normal county jail and let him be among the population. Number 42, Judge Gull's actions of ignoring the defense in matters related to the housing of their client while continuing to communicate with the state of Indiana in an ex parte manner provides a rational inference of bias against Richard Allen and his defense team. Judge Gull invited the prosecution to seek limitations on Richard Allen's Sixth Amendment right to prove that other parties committed the crimes in question. Number 43. Both Judge Gull and the prosecution have known since the filing of the first Franks notice on September 18th, 2023, that the defense will be relying on a third-party suspect defense. Exactly. You've known about this since September, and now the defense wants to, now the prosecution wants to limit them from talking about third-party culprits at all. Number 44, in rebuttal to the defense's theory regarding third-party perpetrators, the prosecution listed an Odinism expert on their supplemental witness list emailed to the defense on March 17th. Number 45, at no time between September 18th and April of 2023 and April of this year did the prosecution take any action to prevent the defense from pursuing a third-party perpetrator defense. Exactly. You've had all these months now to know where we're going with this trial. During this time, the defense conducted many depositions related to the third-party perpetrator defense, and in addition, made numerous requests to the state seeking additional discovery regarding third-party suspects. Number 46, on April 28, 2024, Judge Gull directed an email to both the prosecution and defense regarding scheduling matters and, without any prompting, informed the defense that she was fully aware of the law regarding third-party perpetrator defenses and would be prohibiting the admission of such evidence by the defense unless some nexus between the two could be proven. And that's what I was referring to earlier when I said that she wrote something about like I'm well aware of the third party defense rules. I'm aware of the law regarding it. So this unprompted comment was akin to an invitation by Judge Gull to the prosecution to file a motion in limine that would prevent the defense from presenting evidence that third party suspects committed the crimes. So yeah, she's holding the prosecution's hand. Number 47, well beyond 18. Approximately 12 hours later, at midnight on a Sunday night, the prosecution filed its motion in limine requesting that Judge Gull not allow the defense to discuss third-party suspects. The court's invitation to the prosecution to seek such limitations creates a rational inference of bias in favor of the state of Indiana and against the defense. Her invitation to the prosecution for that motion coming shows that she's biased, is what that's saying. All right, so Judge Gull has repeatedly disparaged Richard Allen's appointed public defenders. I agree, and it's totally inappropriate and wrong, and she should not be a judge anymore. All right, number 48. Beginning October 19th, 2023, Judge Gull began verbalizing her negative feelings about Richard Allen's defense team using such words as grossly negligent, oh my God, I can't say negligent, grossly negligent, and incompetent. There we go. Which is me. When I say those words, I'm negligent and incompetent. All right. Number 49, when Richard Allen's original defense team attempted to enter their appearance for Richard Allen pro bono. This was after she kicked him off, and they were like, yeah, no, not so fast, lady. We'll do it for free. That's how much we want to do this case because that's how much we believe in this client. And Judge Gull would still not allow their appearance to be entered based upon her view that the defense attorneys were grossly negligent and that Richard Allen could not even expect an adequate defense from attorneys Baldwin and Rosie, which is very disparaging if you're a lawyer. All right, so Judge Gull stated the following to Richard Allen at the October 31st, 2023 hearing. Quote, Mr. Allen, I understand that you wish to have Mr. Baldwin and Mr. Rosie present you in this matter. I have grave concerns, Mr. Allen, about their representation of you, the previous filings by this court of their gross negligence. Mr. Allen, you are entitled to adequate representation in your case. You are entitled to a vigorous defense in your case. And this is difficult, Mr. Allen, because I know you've indicated that through your attorneys, but I cannot and will not allow these attorneys to represent you with the concerns I've had with the gross negligence that I've found. Bias. Definite bias there. I cannot let you continue. Whatever. All right, 50. In her comments at the October 31st, 2023 hearing, Judge Gull stated the following: I cannot and will not allow these attorneys to represent you with the concerns I've had with the gross negligence that I've found. These words alone equate to outright bias on the part of Judge Gull towards the defense and towards Richard Allen. I agree. Number 51. Since denying the defense motion to disqualify, Judge Gull has continued to show her bias in a variety of ways, including demeaning Richard Allen's two defense lawyers who have between them over 50 years of experience and zero findings that they are incompetent or have violated the professional rules of conduct. So they've they've got like a squeaky clean record, and McClelland's trying to get them for contempt and stuff. Whatever. All right, so most recently, in her April 30th, 2024 two-page order detailing her ruling on the prosecution's request to find the defense attorneys in contempt, Judge Gull continued her maligning of the defense attorneys, calling them incompetent, negligent, and sloppy in the way that they handled evidence. Furthermore, in that same order, Judge Gull articulated to not only the lawyers but the general public that she would be referring her findings to the Office of Judicial and Attorney Regulation. Judge Gull's targeted comments and reference to the Office of Judicial and Attorney Regulations have no legal relevance to her findings of non-contempt and appear to have been intended only to further disparage the character and fitness of defense attorneys Rosie and Baldwin, and bam, that's exactly what it is. Whether any kind of charges or anything ever happened or any findings ever happened, doesn't really matter. Just the fact that she's putting it out there and saying, I'm doing this, shows that she's biased. And it also taints the potential jury pool and the public thinking that, oh, they must have done something wrong because Judge Gull, she didn't find contempt, but she's still reporting them for something. Which she could be reporting them and they go nowhere. So just because she's saying she's going to do it doesn't mean that it's going to do anything. All right, so number 54. If you didn't like 18, here's 54 for you, and we're not done. While Judge Gull has, on at least 8 occasions, denied defense motions with 3 words, denied without hearing, 8 occasions, Judge Gull felt it necessary to use insulting language concerning defense counsel only 2 weeks before the beginning of a trial. 55. The fact that Judge Gull continues to disparage the character and fitness of defense counsel when she could have otherwise remained silent on the matter provides a rational inference of bias against the defense. Other examples of Judge Gull treating the prosecution more favorably than the defense on 56. Screen is driving me crazy. 56. At the March 18th, 2024 contempt hearing, the defense provided evidence to the court that the Carroll County prosecutor Nicholas McClelland interacted with a social media content provider named Gary Baudet, aka Fig. And we've talked about this in other filings. The defense has talked about this in other filings. Hold on one second. This is driving me crazy. All right, sorry, I had to readjust. Plus, my eyes are bugging me. Reading too much hurt my eyes. All right, so number 56. At the March 18th, 2024 contempt hearing, the defense provided evidence to the court that the Carroll County prosecutor Nicholas McClelland interacted with a social media content provider named Gary Baudet, aka Fig. Fig Solves, Figgy, whatever. I don't know. We've talked about him in other um, motions because he's been brought up by the defense before, stating when they tried to recuse Nick McClelland, they talked about him communicating with this Gary Baudet Fig, whatever Fig solves, and him knowing information. This Gary Baudet knew information and published it on his YouTube channel before it was public knowledge. And because he was getting it leaked to him from the prosecutor, Nick McClelland. The evidence was in the form of emails, including an email in which Fig claimed that McClelland had requested Fig to erase their communications. Number 57, the defense provided evidence that other leaks occurred over the case's history, implying that those leaks could have emanated from McClelland's office. Number 58, while Judge Gull required the defense to cooperate in the investigation of leaks attributed to the defense, Judge Gull seemingly has no interest in similar allegations attributable to the prosecution. So there have been multiple leaks that we could attribute to Nick McClelland, and the judge seems to ignore that. She doesn't care about that. She only cares about the leaks alleged leaks that are coming from the defense. Number 59, Judge Gull's actions, as referred in or referenced in the various paragraphs above, create a rational inference of bias against the defense and in favor of the prosecution. Judge Gull treated the defense team differently than she treated her own office regarding allegations of confidential discovery materials. 60. At the March 18th, 2024 contempt hearing, the defense tendered evidence to Judge Gull. Now I'm like, dog's gotta get up. Okay. The defense tendered evidence to Judge Gull that showed that her staff may have leaked confidential information to social media sources. So the defense provided evidence to Judge Gull about this. What does she do? Probably nothing. All right, so the evidence included emails and video from a content provider named Fig and others, as well as testimony from other witnesses. 62, in a November 22nd, 2022 social media video tendered to the court, Fig detailed sensitive crime scene information that at that time was not available to the public. The defense attempted to admit Exhibit Q, which was a flash drive containing a YouTube video from November 22nd, 2022, in which Fig announced his knowledge of a bullet reportedly found at the scene when this information was still sealed. So he's reporting on evidence that no one knew about yet. The judge refused to admit said document as part of her analysis for contempt, but it was accepted as part of the record for appellate purposes. This flash drive is still available for Judge Gull if she becomes concerned that either McLeland or someone from her office was leaking information to Gary Fig Baudette. So you could have looked into that, Judge Gull, but you didn't because why? Oh, yeah, you're biased against my client and his attorneys. All right, so Judge Gull has shown no concern whatsoever about unmistakable evidence that on November 22nd, 2022, Gary Fig Baudette revealed sensitive crime scene information at a time when that information was not known by the public, later claiming that he, Fig, received said sealed information from Judge Gull's staff. Judge Gull has called the defense incompetent, negligent, grossly negligent, and sloppy concerning the very same allegations against her own staff that Judge Gull has apparently refused to investigate. Interesting, huh? Did I skip a... I guess I did. Okay, so, oh, this is just talking about the proceedings. Never mind. I thought I skipped a footnote. All right, number 65. The defense has no idea whether Judge Gull's court staff leaked sensitive information to a social media site, but there does exist facts to support this allegation. Despite these facts, the defense is aware of no action taken by Judge Gull to investigate these circumstances. This is a stark contrast from the actions of Judge Gull, who in the fall of 2023 endorsed the prosecution and its law enforcement personnel in seeking out suspects associated with the leak of crime scene photos to the public. The fact that Judge Gull has treated the defense differently when the defense is accused of a leak when it is or then it is treated then it has treated her own staff or the prosecution creates a rational inference of bias against the defense. And we are going to stop there. I know there's still more to go. We're only halfway through. So buckle up. Make sure that you have the notification bell on so that you don't miss part 2 of this video. And let me know in the comments below what you think. And please be sure to hit the like button on your way out. I would really appreciate it. Thank you guys so much for watching and take care. I'll see you next time. Bye, guys.
If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.